Hello, we are talking about trust accounts now. Salespersons, you should anticipate 3 test questions. Brokers, you should anticipate 4. I'm honestly surprised it's not more. Not that I'm trying to jinx you or challenge PSI to test you more on this, but there is a lot of trust account questions that could be an option for you to have on the exam. So let's get going. First of all, brokers are required to set up an account that is interest bearing. And every month that interest gets transferred to the state. Sorry, I take that back. On a quarterly basis. Okay. Interest bearing account, the interest gets transferred to the state on a quarterly basis. That's the first thing. The second thing when a broker sets up an account is they've got to sign a form that gives consent to be audited. And there is a trust account auditor with our state that works very, very hard to hold us all accountable. And we want high accountability with this trust account because who do these monies belong to? Someone else. Therefore, deposits or earnest money, and we do not want to commingle those with general funds. Okay. Now, when we set up this interest-bearing account, the law says that it is okay for the broker to maintain $1,000 of their own personal money without it being considered commingling. So the key there is $1,000 on behalf of the broker is allowed. And this is so we can cover bank fees, and mainly because to open an account, you can't open it with $0. So they're doing it really for the banking side, again, to cover just those ongoing bank accounts, because some of these brokerages, you're closing almost 200 deals a month, which means in the next 30 to 60 days, you're going to need to cut an earnest money check, hopefully back to the buyer because they're closing as a credit. So that trust account is such a revolving door. And a lot of times banks charge when you do a high number of transactions or you do a very low number. It's a convenience fee. So they allow $1,000 of the broker's personal money to be put into that trust account, and they don't consider that commingling. Anything above and beyond that, though, big no-no. No commingling. The next thing that I think will be a big one for you is that funds for deposits or earnest money must be deposited into the broker's trust account no more than 5 banking days after the last accepted signature on the purchase agreement. So once a purchase agreement is fully signed by everyone, the clock starts ticking, and you got 5 banking days to make that deposit. That's the standard, unless there's something indicated otherwise. If we do an agreement, I write an offer on your property, and I forgot my checkbook in Alaska while I was here in Iowa visiting, and now I want to write a house, and I don't have any other way to make a deposit, we would maybe specify that the seller would agree to wait on that earnest money till I got home to my checkbook. But if there's nothing written otherwise, the law falls into place that it's 5 banking days. That's a great test question probably for you on the exam. Another big one for you, I believe, is how to deal with funds if a deal were to fall apart prior to closing. So once we've got an accepted offer, earnest monies are deposited. Now, let's say for any reason, the buyer and the seller, buyer or seller, decide not to move forward. What happens to that earnest money? Well, the law says that the earnest money can only be distributed as authorized by buyer and seller. So they either need to sign an authorization form releasing it, or not releasing it, however they agree to it, or they're going to have to go to court or some sort of mediation service and determine it there how it will be released. As a broker, they don't get to decide that. Okay, it's got to be part of the buyer and seller's decision. Okay, now let's say a buyer writes an offer, submits earnest money with it, but the offer doesn't get accepted. What happens to that earnest money? Well, that immediately gets returned to the buyer, no questions asked, because there was never a deal consummated anyway. Okay. Another one that could be a great point for you is the Iowa Code says, under no circumstances is the broker entitled to withhold any portion of earnest money when a transaction fails to consummate, even if the commission is earned. The broker shall pursue any claim for commission or compensation against the broker's client. So let's say a deal gets put together. The seller says, I'll take a cash offer for $280. You bring them a cash offer for $280, and 2 weeks later they say, takesy backsies, we don't want to move. Technically, that's a breach of contract, and that broker has still earned a commission. But the law says they can't just use what's in the trust funds or use for earnest money to make up part of that commissions. That earnest money belongs to someone else. It needs to get released according to written authorization by buyer and seller. So if the broker wants to make their money on commission because of that breach of contract, they are going to have to go to court and pursue some sort of legal claim. Okay. For closing transactions, this is a good time to remind you that all documentation by the broker, including trust account information, must be maintained for a minimum of 5 years. 5 years. Now, here's the next thing that the Iowa Code says. It says any means other than cash or an immediately cashable check shall not be accepted as earnest money unless that fact is communicated to the seller prior to the acceptance of the offer to purchase and is stated in the offer to purchase. So if you just write $1,000 for earnest money and it's accepted, it's assumed by law that that is going to be cash or an immediately cashable check. You cannot just then all of a sudden say, surprise, here's my Cabbage Patch collection that according to eBay is worth $1,000. Okay. Now, if you wrote an offer that said you would put down your 1-carat diamond ring, and the seller had that as part of the original offer, saw it in writing and accepted it, then that's okay. Now, that is the state law. For those of you getting licensed and maybe setting up your own brokerage, you may have a policy individual to your brokerage that is different than that. You maybe don't want to deal with housing someone's Fabergé egg as an earnest money deposit. I get it, right? That would probably require a totally different level of insurance, but the Iowa Code allows it. So don't confuse what you maybe know at your brokerage as a policy with the state law. But again, if you're looking to open your own brokerage, there's a business decision that you get to make. This is our summary of trust accounts. Again, I think I've probably given you about 5 or 6 options for test questions that I think you should be very mindful of. Again, good luck.